Namaste. I'm Swarna. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Office of Prashanthi Reddy PLLC. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to www.reddysq.com for contact information. When you contact, when there is no need to forget about asking anything, and you can always mention Sakshi TV for beginning. PrashantiReddy.com has put a wealth of free information and online tool in the hands of immigration community and for the benefit of US employers. The www.reddysq.com site provides you with the latest and cutting edges of information on US immigration law and policies explained in terms you do not have to be a lawyer or to understand. Before we get into the topic, you can call us on the number on the screen for questions related to the immigration and also ask the tips. Hello, Ms. Prashanthi, how are you?
Hi, I'm good. How are you?
I'm good, thank you. Before we get into the topic, do you have any latest immigration updates this week?
I think let's just go directly into the topic.
Okay. So today's topic is H-1B cap RFEs. What to expect and how to respond. So can you please provide us more information about it?
Right. Okay. So let's start with what is collusion again and what is not, because that's, I think, one of the issues that you could get an RFE on. So USCIS on February 24, 2022, via its website made an announcement regarding the H-1B cap FY 2023, fiscal year 2023, and USCIS announced a new attestation requirement for companies to prevent them from filing frivolous H-1B registrations for the sole purpose of increasing the chances of applicants being picked under the lottery. And if they do this by colluding with other companies with the sole purpose of only increasing a person's chance in the lottery, and if they don't have an actual valid job offer, then USCIS will consider that to be collusion. So not only have they included an attestation in the registration this year, for all of you who have filed for a H-1B registration, you have signed off on an attestation that the job offer is valid, and you have also signed off on the attestation, part of the same attestation, that you have not colluded with any other company to increase the chance of the beneficiary getting picked in the lottery, which basically means that for example, if you have decided along with company A, B, and C to file for the same beneficiary or for the same set of beneficiaries, and each of you doesn't have a separate job offer, but you're simply filing registrations for the same job offer, meaning that person is going to work at AT&T, but company A, B, and C are consulting companies. They have all filed the same registration for that same job at AT&T, just for to increase that beneficiary's chances of getting picked. So that is not allowed, and that is collusion. So if you file a H1, if you filed a H1 now and you have done something like this, then you have attested under the penalty of perjury that you will not do it, and if you've done it, then it could lead to not only RFEs and notice of intent to revoke if the case has already been approved and they notice it afterwards, but also to criminal penalties or liabilities. So just be careful. If you do get such an RFE, you have to show, and if you did not collude, then you have to show that it was not collusion. You have to show that each of you did not come to an agreement, whether oral or written, that you would each file an application for the same beneficiary and then share the resource, as is. So what is not collusion? So if you get an RFE, if you have not colluded, then how can you respond? So first of all, you have to understand what is not collusion. So beneficiaries can independently file for multiple companies as long as there's no collusion between those companies. It's not necessary that company A, B, and C did not know that the beneficiary is filing with other companies, but as long as they did not work with other companies and agree that they will file, with one intent in mind to increase the beneficiary's chances of getting picked. So beneficiary independently can go and file with separate companies, with or without the knowledge of those companies. Also, say one person has 3 different companies, or several companies have filed for the same beneficiary. It's not always collusion. It's not collusion even if they know that each other have filed, or as long as the job offer is different. As I said, if you're filing for that same AT&T job offer, then it's collusion. But if each company has their own job offers, for example, company A might require that candidate to work with AT&T, company B might require the candidate to work with Chase. So each company has a different job that they're offering the beneficiary. So if you're able to prove that, and if you get an RFE, then you can still overcome that RFE by showing that there was no collusion. It was a bona fide job offer. The job offer was separate and distinct from the other companies. Or you can always also say that, the beneficiary filed for these separate, with these separate companies, and you did not collude with any companies to file. So I hope that's clear as to what is collusion and how do you respond to an RFE if you do get an RFE with alleging collusion. Also, if you get an RFE and if you have actually not colluded with any of those companies, but it seemed like USCIS is saying that the same 30 candidates were filed with company A and company B. If you say you didn't collude, then it might be too much of a coincidence for USCIS to believe that you had the same set of names as company B. So you have to show, maybe it's possible in that case that you had a common recruiter and they shared the same resumes to company A and company B. So that could be one explanation of why it seems like there's collusion, but actually you did not collude. So you have to explain that, and you have to show that in an RFE response. So that's one significant reason this year why this year for an RFE to be issued by USCIS, collusion. Second most common reason, actually the primary reason, always their favorite, is an RFE based on the fact that the occupation, USCIS thinks the occupation is not a specialty occupation. So failure to establish that the position qualifies as a specialty occupation is the most common reason for an employer to receive an RFE. So in order to qualify it for a H1, you have to show that the job that's been offered requires a bachelor's degree in a specific field. And you also have to show that your beneficiary has that particular qualification. Say for a software engineer, the requirement, industry-wide requirement is a bachelor's degree in computer science. You have to show that, not only that your job requires a computer science degree, but also the beneficiary has one. So how do you show that your job requires a bachelor's degree in a specific field? It could be through your job description. So it's important that you make sure that you give a detailed job description in the petitioner letter. Or at this point, you're responding to the RFE. So even if you didn't do that in the petitioner letter, make sure in your response to the RFE, you give a detailed job description. You show the complexities of the job, and you, if required, make a table showing why the job requires a bachelor's degree in computer science. So put in the job duties, and for each duty, explain why a bachelor's degree in computer science is required, or what knowledge is required that essentially comes from a bachelor's degree. So you can compare the transcripts of your bachelor's degree with the job duties that are mentioned. You should also, if you get an RFE such as this, asking for specialty occupation, you have to show that in the industry, it's common to require a bachelor's in computer science in this particular case. How do you show that? Most common and easiest way is to look at the Occupational Outlook Handbook, which is a publication of the Department of Labor, and they have a lot of occupations in there, not all of them, but they have quite a few of them. So if your occupation is in there, and if the OOH, by the way, which is available online, you just have to type in Occupational Outlook Handbook. And so if the OOH says that a bachelor's in computer science is required for the position, then it's definitely a specialty occupation. And you don't really need to look much further to prove that it's a specialty occupation. But some occupations are not mentioned. In some occupations, very little information is there in the OOH. In some occupations, the OOH will say, oh, a bachelor's in engineering is required. And USCIS might then say that, it doesn't require a major in a specific occupation. Engineering is too broad. So, these are some of the challenges that you might face when you file a H-1B and if you get an RFE for a specialty occupation. Another way to show that it's common in the industry to require a bachelor's degree is to go to DICE or go to some other job search website, print out all the job positions that you see for your position, say it's a software engineer, and then send them printouts of all these positions that require a bachelor's in computer science. So that's one way of showing it's common. Another way of showing that it's common to require a bachelor's degree is show that you've hired a person or people with bachelor's degrees in computer science for software engineer positions in the past. So submit the W-2, submit their degree certificate, submit their pay stubs, make a list, and show that you always require it. And that's one way of showing that you're not, trying to do something in this particular, something different in this particular application, but you've always required bachelor's in computer science for, a software engineer position. So specialty occupation is a biggie. Make sure job descriptions are mentioned properly. Make sure the job description can be linked with the educational requirement of the position. And, you have to write, you can't just write a response in 2 lines. You have to actually explain the complexities of the job, explain if it's not common for other people to require a bachelor's, why you need it. What is so complex about your job description that you require it, and how do you differentiate it from other jobs that usually don't require a bachelor's degree? So these are some tips for specialty occupation. And I'm focusing so much on this because this is asked the most. Another reason is availability of work. Usually USCIS will send an RFE asking if there is specialty occupation work available for this person. And most often this happens when you are a IT consulting company. Doesn't happen so much if you belong to some other industry, say a law firm files a H1, they don't usually send an RFE for availability of specialty occupation work. As long as you show that you are a functioning, profitable business, they won't really pay attention to availability of work. They won't send an RFE. Accounting firm, same way. So in many industries, they won't, but if you're a consulting firm, because you're hiring a person for them to work at another client site, they want to see who that client is. So with reference to this RFE, you have to submit, if they're working at a third-party work site, you'll have to submit specific non-speculative work assignments in your position. So POs, contracts, letters from vendors or letters from clients detailing the job. That's what they're looking for. So important if you are filing if you have already filed a skeleton petition whereby you have not really explained where the person will work or you have not documented it, and if you are a consulting company, you may expect an RFE. It's important to remember that you have to show that the person had availability of specialty occupation work at the time of filing the H1. So you can't have a PO which is dated at the time of responding to the RFE, because you have to show that you met all the requirements as of the date of filing the H1. Okay, so that's important to note. Another reason why they could send an RFE is the beneficiary's qualifications. And we talked a little bit about this already. If for example, the beneficiary has a bachelor's in, say, chemical engineering, right? And if you're chemical engineering, then basically the person is going to be working as in the IT field as a computer science professional, say as a software engineer or a systems analyst. Then it's important to note that you might get an RFE asking how the beneficiary's degree is related to the duties of the position. So in this case, if say you have a chemical engineering degree, the way to respond to that kind of an RFE, showing the correlation between the degree and the job duties, is prepare a table again, show the mark sheets or the transcripts, and each degree, each subject that's related, show the correlation between the subjects in the transcript and the job duties. So for each job duty, you will mention how that relates to the degree. So that's one way of doing it. Another way of doing it is if you have, say, 3 years of work experience in the IT field, you can get a work experience evaluation, expert opinion evaluation done, because 3 years of work experience is equivalent to 1 year of degree. So if you have already an engineering degree in, say, a different field, such as chemical or industrial, you add the 3 years of IT work experience and you get an evaluation done, you'll most probably get a bachelor's in information systems, which is related to computer science and therefore related to the job. So there are two ways of doing it. Either show how your degree relates directly by looking at the transcripts and highlighting the subjects in your transcripts, or you get an evaluation done, a work experience evaluation. So beneficiaries' qualifications are very important. Maintenance of status is another reason why you could get an RFE. Say if you don't submit status documents, which means that you don't submit your I-797 approvals or your I-94 approvals, they cannot then, if you're filing a CAP case and say you're on an F1 status, then you have to show that you are on F1 status as of the time of filing. And if you don't submit documentation to show that, whether it be an I-20 if you're presently in school, or an I-94, or if you're on OPT, then the OPT copy of the OPT card or the I-797 approval, then they're going to send an RFE asking you for proof of status. So very important. If you're on a B1 or a B2 and you're filing for a change of status, you have to make sure that your status does not expire until the start date of the H1. So if it's a CAP case, your start date is October 1st. So your B2 I-94, if before it expires, if you're filing an extension, go ahead and file the extension. But by the time you get the RFE, you should be able to show that you've either filed an extension or you've received an approval for the B2. So it's not enough at the time of filing that you're in status. You have to continue to be in status as of October 1st, the start date of your H-1B approval. So something to keep in mind with reference to maintenance of status and CAP cases. This doesn't apply for transfers and extensions, but for CAP cases, this applies. Another reason you would get a maintenance of status RFE is for F1 students. They want to make sure that you're enrolled in a full-time course curriculum. They want to make sure you're a full-time student. They want to make sure that your classes are not online. During COVID, many classes were online and there were special rules which allowed students to take online courses. But normally they only allow you to take 2 courses online. So they want to make sure that you're studying full-time in person. They also want to make sure that if you're on CPT, curricular practical training, there was a reason that you are on CPT, meaning that your school allows you to be on CPT, and you have to show the relationship between the courses that you're taking and the subjects that you're studying. So that's very important for CPT. So they will ask for that information in an RFE. Say you're on OPT or a STEM OPT or post-completion OPT. Again, you have to be working. For post-completion OPT, you can volunteer, but you don't have to be paid, but you have to show that you worked. So you need an experience letter. For STEM OPT, you have to work for a certain number of months. I believe 90 days you don't have to work, but the rest of the time you have to show that it's paid employment, not unpaid. So you have to show not only expense letters, but pay stubs as well. So these are some of the nuances or some of the things that they ask for in, a CAP change of status case, especially change of status from F1 to a H1. The other thing is the availability of work. This can be, so we talked about availability of work outside of the petitioner's office, meaning that you're working at a client side, but they could also ask for availability of work even if you're not working at a client side. They want to know, especially if you're a consulting company, what project you have for the beneficiary, what work they will do. If you have several projects that they will work and they're going to work remotely or work in your office, then you'll have to submit contracts of several projects to show which projects they're working on. Or you just have to, in general, show that you have enough work and several assignments lined up, for the beneficiary. Or if you're developing your own product, then you have to show documentation such as project report, marketing analysis, financial cost analysis, everything that you've done, all the homework that you've done before you launched your product, and also screenshots of your product. If that product is already being used by someone, then you'll have to submit contracts or payments that you've received from your clients. So there's a lot of proof that you have to submit to show that you have availability of work in-house. And another last, I think we only have time for one more reason to get an RFE is the LCA. If you don't file the LCA properly, or if there's something unclear in the labor condition application, then you might get an RFE. So you have to make sure that everything that's in the LCA corresponds with your petition. So in your I-129 form, which is your H-1B petition, there has to be the same information with reference to the job title, the wage level, and where the work will be performed. So all that has to correspond, because remember, you cannot change the LCA once your H-1B petition is filed, because you have to show that the LCA was approved before the filing of the petition. So if there is some mistake in the LCA, you'll have to submit the entire petition again. If it's a CAP case, you're out of luck because you can't file CAP cases anymore. The deadline is passed. So just be careful with reference to, when you fill in the corresponding information from the LCA to the I-129 form. I guess we have time for one more point. Another point is, and this doesn't apply in CAP cases, this is generally in extensions or transfers of H1s, is when your 6-year limit seems to be up or appears to be completed, then they will send an RFE saying that, look, it looks like you've already completed your 6 years. On what basis are you asking for a 7th year extension? So in order to do that, you'll have to show in a response to the RFE that you have either an I-140 approved, which will give you 3 years extra, 3 years increments of extensions, or you have to show that you have a labor cert pending or an I-140 pending, which has been pending for more than 365 days. That'll give you a 1-year extension. Or you can also show that you have, you're trying to recapture time spent outside the country. Like, for say, in the last 6 years, you've spent 1 month every year outside the country. You have 6 months left. So you can submit that those I-94 details of arrival and entry into the country, which you are available online. And you can show that, you're asking for recapture of that 6 months. So that's, I think, Shivani. The other thing is fees. The last thing I would talk about is the fees. Make sure you submit the correct check to USCIS. The fees are complicated. Depends on the size of the number of employees that you have. So if you have over 25 employees, then it's 1,500 plus 460 plus 500. If you have less than 25, then it's 750 plus the basic 750 plus the basic 450 plus 500. So it's complicated. So you need to look carefully as to what the fees is and submit the right fees for for your application. Also make sure you write the check correctly. Don't make a mistake with your check. Date it correctly, write it in words correctly, write the numbers as well, and sign it. So these are the few, I think 8 points we covered, Shivani, based on which
Yes.
RFEs are usually sent and how we can respond to those RFEs.
Yes. Thank you so much, Ms. Prashanthi, for your time and all the information you have provided us. So once again, thank you for coming to our show.
Thank you.